Good morning. My name is Eugene Meehan with Supreme Advocacy LLP in Ottawa, in Centretown, Ottawa, walking distance from the Supreme Court of Canada building. I'll be looking at leaves to appeal in this particular video. So, let's say you or your client, you lost at the Court of Appeal. I've been there, I've seen that movie. I have in many cases applied for leave to appeal, got it, sometimes not. Sometimes won the appeal at the Supreme Court of Canada, and yes, sometimes I've come in second. So I'm going to be very practical today, and I will go through 5 strategic substantive points and then 5 technical compliance issues that you may think are rather small and not important, but they are. So you're ticked off at losing. You've got 3 deaf judges, as it may appear, even though it's not in fact the case. Yes, I've seen that movie too. And that is the first of my 5 strategic points. Ticked off at losing, not the 3 deaf judges, and what do you do? So number 1, you're ticked off at you lost and you want to go to the Supreme Court of Canada. Well, what now? Well, you've got 60 days in most cases to put your leave to appeal in. My suggestion is you wait until you and or your client have cooled off from losing at the Court of Appeal. Make the decision carefully, objectively. Ask the question, will your client be satisfied with the understanding what the leave to appeal standard is? Will your case satisfy or be made to satisfy with your contribution as a lawyer that you can meet or exceed the standard for leave? Do the chances of success warrant the cost and trouble of doing that? If you have lost at the Court of Appeal in a particular province or territory, is there a risk that appealing to the Supreme Court of Canada could mean losing there too, and thereby establishing a negative countrywide precedent? Is that the risk? Is there a solid and substantive basis for the appeal as compared to a procedural or interlocutory one, and are the issues really suited for a determination by Canada's highest court, Canada's national court? Is the decision below, for example, based more on credibility or findings of fact? Even if there is an error of law below, is it so substantial as to have affected the outcome of the trial or the Court of Appeal decision? And are you really filing a leave to appeal because your clients want you to, or because it is your considered and professional opinion that an appeal is in order and does have a realistic chance of success? Are there Court of Appeal decisions? And this is the classic way in, but it's not the only way in. The classic way in is, are there Court of Appeal decisions in opposition to one another in different parts of the country that require settling by Canada's National Court? If there's a charter issue, was it squarely raised at trial and not just at the Court of Appeal? And is there a sufficient factual basis for the charter argument? And if a particular provincial or territorial statute or regulation or a provision thereof is an issue, are there similar provisions in other provinces and territories and federally, which one could argue would be directly affected by a Supreme Court of Canada decision? The Supreme Court of Canada is open for business. They are hearing appeals. They are giving judgment on appeals and leaves. And they're looking at all areas of law, including civil, commercial, and other types of litigation. Everything from family to wills to intellectual property, personal injury. Anything from A to Z, from agriculture to zoning. Number 2, what is the test? What standard do I have to meet to get leave? The standard, even though it's rather circular, there's a circular definition in section 40 sub 1 of the Act, which says something is of public importance if it's of public importance, kind of. There's a more realistic and practical standard set out by Madam Justice Wilson, a Scottish lady like myself, well, Scottish part, not the lady part, in a 1989 decision where she said it is important to look not only at the impugned legislation but also to the larger social, political and legal context. Former Chief Justice McLaughlin has also written in some remarks, when considering whether to grant leave to appeal, the court looks at whether the issue in some way extends beyond the interests of the immediate litigants. Now, another standard way which may be realistic is the following. Does this sound like an interesting appeal we'd like to hear argued before us? And if that is the test, if If that is the real test, then strategic considerations come into play as to how you draft the leave to appeal factum and the response factum, if that is the test you wish to fail. Justice Moldaver says that one of the most common mistakes counsel make is to misperceive the Supreme Court as being a court that tries to catch trial errors and ensure a correct result for the litigants. He described the court's role as scrutinising the big picture, and he says, quote, "It is not about what the law is, it is about what the law should be. It is about what is best for Canada and Canadian citizens. I would say," he says, "that just about 10% of what we do is error correction. The other 90% is jurisprudential." Number 3, how many leaves get granted? Well, that of course depends on, number 1, how good, pragmatic, focused, strategic your leave is. Number 2, is it an issue that the Supreme Court of Canada wants to deal with and should deal with, and you argue to them that they should deal with this? The percentage itself varies from year to year. It's about 10 to 12%, and that includes everything. That includes what the court describes as inmate write-ins. Those are not bad odds, because in SCOTUS, the Supreme Court of the United States, to get a cert, their equivalent of a leave, it's about 1 to 1.4% at the present time. But you can significantly increase your odds, very much so, by how good your leave is, making it practical, pragmatic in a way, in a legal way, strategic, focused. So let's come to some basic but fundamentally important content suggestions. But first, very briefly, the most up-to-date stats from the court to show the areas of leave applied for, and that is as follows. Civil procedure, 14%, criminal, 16%, charter non-criminal, 7%, charter criminal, 5%, administrative, 5%, torts, 5%, contracts, 4%, property law, also 4%, judgments and orders, also 4%, tax, 4%, constitutional law, 4%, municipal law, 3%, courts, 3%, other, 22%. And that's a sort of a fairly broad band. But as I mentioned above, the court is dealing with everything. Everything you studied in law school, they're now dealing with. Number 4, some basic but important content suggestions. And let me make 4 suggestions here. 1, the opening. Your factum should create anticipation immediately, not do the standard boring procedural history opening, like stuff happened before there was a trial and then the Court of Appeal. That's kind of boring, because there's no point in pitching that to the Supreme Court of Canada. They know that. So a strong, focused opening paragraph emphasising the public importance or lack of public importance if you're the respondent can be effective. Number 2, bookending at the closing. Likewise, the closing can be very effective, can pull the whole factum together into one whole. It gives you the opportunity to rephrase, redevelop the opening, give the factum a feeling of circular logic, that everything is there. Number 3, the facts. The facts are not easy, actually. You might think they are, but they're not. It's important that you keep them short, 1 to 3 pages max. A good way to start, and I suggest you start this way because it's a way to help you organise the facts, is to start by saying a brief chronology is as follows, and then give a series of bullets with subheadings. Number 4, public importance. Do not be tempted to argue the whole appeal at the leave stage, or do a redraft, as some lawyers do, of your Court of Appeal factum. It's all different now. There's only one point, one important point, one theme: public importance. Number 5, the final fundamental point with regard to that overall is the facts, because the facts for the applicant, you may think is something that is something of strength. It's actually your greatest vulnerability, potentially your Achilles heel. The Supreme Court presumably wants cases with clean, settled facts, not cases with highly disputed facts where they are called upon to be kind of like trial court number 2 or trial judge court number 3. That's not going to work. Now, 5 technical compliance issues, and you may think, not that important, mere technicalities, content beats that. No, for 2 reasons. Number 1, if your factum looks sloppy, even slightly, looks quickly done. Yes, small things. For example, Is it paginated at the bottom, top left, top right? And many people do it different ways. The rules are clear, it's top centre. Then might a Supreme Court of Canada judge say or think, if this case is so important, why were not the rules closely followed? Why does it look quickly or sloppily done? And number two, the closer your factum is to the standard format the Supreme Court judges generally see leave factums, then the more convincing your materials are, the more convincing you are, and the more professional you and your client looks. So we've covered a lot today, but here's 5 really brief technical compliance points, and they're common errors that many counsel make, that you don't want to go there. Number 1, spacing. Proper spacing of your document is 1.5 with the exception of quotes. It's not helpful to try and jam everything in. Number 2, footnotes. I know we all want to squeeze everything in there, but footnotes must be 12 point. Any footnote that contains more than just reference information must also be spaced at 1.5. Don't jam stuff in there either. Number 3, table of authorities, alphabetical. Paragraph references for each authority, and that's references to paragraphs in your factum, not paragraphs in the authority themselves. Number 4, spelling. Check your spelling, particularly the names of corporations and individuals referenced in the trial judgment, the Court of Appeal reasons. Do not rely on spell check. Do not rely on grammar check. For example, trail judge will not be caught by spell check. So if you type trail judge instead of trial judge, won't be caught. Nor will the rapist instead of therapist. That won't be caught either. Number 5, certificate of counsel. You must indicate if there are any sealing orders or publication bans, and indicate on the PDF copy of the memorandum if it is, quote, suitable for posting. That's it. Thanks for listening, watching too. If you are interested in further reading about appellate advocacy at the Supreme Court, here now is a list of further reading. If you are curious about what our firm does here and what my colleagues and I do here, here is a list now of our services. Thank you, merci. If you would like a copy of the text of this video, email me at email@supremeadvocacy.ca and I'll get it to you. Any questions? Email me at the same address, please. Merci encore.